welcome to Arbitration Acumen, a podcast from Bracewell's International Arbitration Group that connects in-house counsel and arbitration practitioners with industry experts, institutional insiders, and top arbitrators from around the globe to share their views on key issues in arbitration today. You can reach out to any of today's speakers by emailing arbitrationacumen@bracewell.com. And we hope you enjoy this episode of Arbitration Acumen.
Welcome back to the next episode of Arbitration Acumen, in which we'll discuss the JAMS Mass Arbitration Procedures and Guidelines with Liz Carter, who's JAMS Senior Vice President for the East Coast region. For those who haven't been following along, this is the second installment of a multi-part mini-series we're doing on mass arbitration, which has been really fascinating and educational for me, and I'm sure you'll find this episode useful as well. Before we begin, let me just make some introductions. I'm JP Duffy. I'm an international arbitration partner at Bracewell based in New York that acts as both counsel and arbitrator in arbitrations seated around the world under a variety of governing laws and arbitral rules, including the JAMS rules. I'm qualified in New York, England, and Wales, and the DIFC courts in Dubai, where I used to live and practice. With me today is Liz Carter, and as I mentioned at the outset, Liz is the Senior Vice President for JAMS's East Coast and Central region. She oversees JAMS operations in the Central and Eastern U.S. and is actively involved in marketing and business development initiatives as well. Prior to her current role, Liz served as the General Manager of the New York Resolution Center, and before that as the Business Manager for the Chicago Resolution Center. Before joining JAMS, Liz was a litigator in both Wisconsin and Ohio, where she litigated commercial disputes in both courts and arbitration, and she's a member of the state bars of Illinois and Wisconsin. Liz is one of the primary drafters of the JAMS Mass Arbitration Procedures and Guidelines, which I'm going to refer to as the JAMS procedures going forward. So we're really fortunate to have a true pioneer in the mass arbitration field here to speak with us today. So Liz, thank you so much for joining us. Really looking forward to hearing from you.
Thanks for having me, JP. Happy to be here.
Great. Well, before we jump into the substance, let me just give a very quick run through on JAMS for those members of the audience that may not be as familiar. JAMS was founded in 1979 in California and bills itself as the largest private alternative dispute resolution provider in the United States. It's got 500 neutrals and handles over 21,000 cases annually in a range of different disputes, including mass arbitrations. JAMS now has 29 offices in the U.S., as well as international offices in London and Toronto. For more information about JAMS, I'd encourage you to listen to episode 2 in the Arbitration Acumen series, where Bob Davidson and Sherman Humphrey, both with JAMS, give some very helpful background on the organization. So with that background, let's turn to Liz and hear from the expert herself. Liz, why don't we start out just by talking a bit about mass arbitration generally? And I think it'd be really helpful for the audience to hear, what exactly is mass arbitration?
Sure. Good question. And most general counsels probably know something about this if they have a number of employees that they work with or a number of customers that they serve. But mass arbitration is a legal strategy where a large number of similar or exact claims are filed individually in arbitration at the same time, usually against the same company, and oftentimes the claimants, the individuals, are represented by the same lawyers or law firms. At JAMS, the number of cases to be considered a mass arbitration is 75, but parties can consider an arbitration filing of 10 a mass arbitration filing, and oftentimes it's several thousand or 100,000 cases.
Wow. Okay. So what are some of the contexts or some of the examples of contexts in which these claims arise?
Usually you'll see mass arbitration cases arise in consumer or employment cases, and it's more often in consumer cases than employment, although we do see employment mass arbitrations filed as well. And these usually happen where companies require arbitration instead of allowing a class action lawsuit or even just a single party lawsuit in court. A company's contract, usually the terms of service or the employment agreement, require arbitration, and they ban class or collective actions. So plaintiffs or claimants in arbitration, the attorneys will represent hundreds or thousands of people with similar claims against the company. and they file separate arbitration demands all at one time. And it's important, I think, to note that this is often due to the specific language in the contract. It's the only remedy prescribed for the claimants, the customers, that they file individual arbitration demands to have their disputes heard.
Okay, that's really helpful. So let me unpack that a bit because I just want to start with one thing that I think is interesting. So JAMS is seeing more mass arbitrations in the consumer context than in the employment context.
Yes.
Okay. And you gave this definition, I think, a little bit earlier, but let me just put a fine point on it. How exactly does JAMS define mass arbitration?
So we define mass arbitration as any group of filings for demands for arbitration. We say at least 75 cases. That's what our procedures prescribe. 75 or more cases filed with similar claims by individual claimants, often represented by the same law firm, against one company.
Okay, so you could theoretically have 75 individual claims that are all very similar against the same company, have them all be by different counsel, and they could still constitute a mass arbitration.
It could. We don't see that very often. Usually there's one claimant's counsel or law firm that's representing a large group of individual claimants. And we batch them, or we not batch them, but we consider them mass arbitration filing when they all come in with the same law firms, or there may be law firms acting in concert with each other, but the same group of claimants' lawyers are involved in these cases.
Right. Okay. And that's usually part of for lack of a better term, a legal strategy by the claimants themselves.
Yeah. I mean, yes, I agree. It's a legal strategy, and it's often, the only strategy they really have when there's hundreds of thousands of potential claimants.
Sure. Yeah. Now, you mentioned class action litigation and that mass arbitration is usually an alternative to that that's dictated by the contract. How does mass arbitration differ from traditional class action litigation?
Good question. So in mass arbitration, we have multiple claimants and individual claims versus class action, where you have one class with a representative. In arbitration, it's private and confidential usually, or the arbitration provider keeps it private. And, a class action is court proceedings, public. Arbitration is governed by contract. Class action is governed by court rules and whether or not a judge certifies a class. Speed can be a differentiator. It's not always, but the goal of arbitration is to be faster and more efficient. So it's usually faster, not several years, that class actions can take to get through the process. Another difference is in mass arbitration and arbitration in general, you get individual awards. And in a class action, you either have a global settlement or a judgment, one. And arbitration, claimants opt in to the process, and class actions, plaintiffs opt out of the process. Those are some of the differences.
Yeah, and that last point I think is really critical. In mass arbitration, you opt into that as an option, whereas in class action litigation, you may not even be aware that it's going on, but you would have to opt out in order to be excluded from the judgment that came out, I guess. When did JAMS first start seeing mass arbitrations?
We saw our first cases come in late 2017, early 18, but the numbers didn't really start to tick up until about 2020. And that's when we started to see multiple mass arbitration filings come in.
Now, was there any correlation between COVID and 2020, or was that just a coincidence?
I think it was a coincidence, but it's interesting. Several years ago, when companies started adding class action prohibitions to their arbitration agreements, there were warnings that were out there about how this might change the game and how plaintiffs were able to resolve their disputes and that this could happen. But it wasn't really until 2020 when we started seeing a great number of these come in.
Okay, got it. Now, how did JAMS initially handle the mass arbitrations that it started seeing in like 2017, 2018?
We've evolved technologically in how we can handle these cases, but the truth is procedurally, we handle them the same today as we did when we got our first one in. We follow the party's contract. That's, at the end of the day, what we do. If an agreement allows for a consolidation or coordination of cases and it makes sense and, a party could request it or JAMS can determine whether or not consolidation or coordination is permissible or allowable or preferable, we will consolidate cases. But what we see is oftentimes the contract expressly prohibits consolidation, coordination, or representative matters, and the contract mandates that claimants bring cases on an individual basis. So we have never felt that we were in a position to unilaterally change a party's agreement. We're not parties to the agreement, and the parties have agreed in some way that this is how they want to proceed and resolve disputes. So we feel forced to follow the contract. The mass arbitration procedures that we developed give the parties a way to streamline the process, but they have to agree to it pre or post dispute.
Got it. Okay. Well, yeah. And that's good to hear. As somebody who drafts a lot of arbitration clauses, I can tell you those prohibitions are put in very, very consciously many times. Now, when did JAMS first consider introducing the JAMS procedures?
We had talked about it for years. In 2020, 2021, we started talking about whether or not we needed to develop some kind of process because we were hearing complaints, especially from respondents, but from both parties about how cumbersome the process could be when you have 100,000 individual arbitration demands. But we waited because, again, we were nervous about forcing a process on the parties that they did not intend or agree to. So in 2024, we really decided to put pen to paper and develop procedures that could streamline the process, get the parties their day in court, produce awards that would be confirmable. And we did that by writing the procedures and letting the parties know that we will use the procedures, we'll apply the procedures, but only if the parties have agreed to them. So the parties can agree to them post-dispute, and they can also agree to them pre-dispute in terms of service or, wherever that arbitration agreement is located. They can reference our mass arbitration procedures and we'll apply them.
Wow. Okay. So that's a really important point for everyone to keep in mind is you can't be forced to accept the JAMS procedures unless you do consciously agree to them. So that's an interesting point.
That's a differentiator between us and some of the other arbitration administrating bodies. We make the parties agree to the process.
Right, exactly. Because I was just going to mention, I know we will have other episodes in this mini-series, and in those episodes, we talk to other institutions where they will simply route mass arbitrations into the procedures, like their own versions of these procedures. Whereas with JAMS, you've got to agree to it. So pretty interesting.
Yeah.
Now, as one of the drafters of these, how long did it take to draft these up?
Several months. We moved pretty quickly, and I think it took less time than we anticipated because we had been perseverating for so long over whether or not we wanted to introduce these procedures. So once we probably started in about November of 2024, and they were released in May 2025.
Got it. That is pretty quick. That's impressive. Now, how many matters has JAMS administered under the procedure since their introduction?
We've had only 12 mass arbitrations come in that have referenced the mass arbitration procedures. But what I will say is we started seeing this 2022, 2023. We've seen a lot of cases where parties have agreed upon a process that may not be the mass arbitration procedures, but some kind of process for dealing with a mass filing. Companies have, in many cases, changed their agreements to provide for some kind of batching or bellwether process when X amount of demands are filed against the company. So we've got our mass arbitration procedures. We've done about 12 cases with that, but we've done several where there's been some variation and some mass arbitration process that's been contemplated by the parties.
Okay, now and we're going to talk about the mechanics a bit more in a second, but you referenced, I think, earlier cases or mass arbitration filings that involved hundreds of thousands of claims before the JAMS procedures were introduced. Am I capturing that correctly?
Sure, there are some. Yeah, absolutely.
Okay. So before the procedures were even introduced, there were mass filings that involved hundreds of thousands of claims.
Yes. Yeah. And
wow.
That's, it's funny. That's why JAMS and some of the other arbitration administrators came up with these procedures. It's very difficult for a company and for a plaintiff's firm to manage hundreds of thousands of individual cases, right? And the fees can be astronomical, the amount of paperwork, the number of arbitrators needed. But at the end of the day, it's a drafting issue, right? It's an arbitration agreement issue. And so I do see parties and companies now really thinking about, is there a way for us to deal with these mass arbitration filings in the terms of service while they still want to protect their interests or, have that class action waiver? But there are efficient ways to deal with these, hundreds of thousands of cases to, number one, take care of the company's customers, and number two, to, make sure that there's a legal remedy when there are disputes.
Got it. And those cases, the ones that you're referencing, it sounds like that was probably a consumer case.
Yes.
Is that right? Okay.
Absolutely. Yeah.
Got it. Well, then let's talk a bit about the mechanics of how this all works, because I think that is, to someone like me, that's a really mysterious process. And it's not a function of how well the JAMS procedures are drafted. They're very clear. I just think as a practical matter, it's great to hear from someone who actually has dealt with these in detail more than once. So just tell us a little bit about how the procedures work.
Sure. So we have parties usually contact us first when they plan to file a demand for arbitration. They let us know. We have an arbitration demand team. We have a team of people who do the intake for all of our arbitrations. So they will send our team their demands and the contract. First thing we do is look at that contract to see what rules are called for and whether or not the mass arbitration procedures are specified in the contract. So let's just assume that they are specified in the contract. Anytime there's 75 or more demands for arbitration, and it's important to know that the parties can agree on a different number. The party's contract could call for the mass arbitration procedures and say, if 15 demands are filed, we want the mass arbitration procedures to apply. JAMS defaults to 75. The parties can agree to something less or more. Then we consider that a mass arbitration filing, apply our procedures, and then a process administrator is appointed by JAMS. And that individual, who is a JAMS neutral, and who's gotten the JAMS training and is a JAMS arbitrator, they schedule a conference call or a meeting with the parties, and they really get in there and start to figure out how we're going to get these cases to a merits arbitrator or several merits arbitrator. So the process administrator is really deciding how these cases are going to move to a final hearing. Are there going to be batches? Are there going to be bellwethers? Is there going to be a schedule? How are these cases going to be divided? Are they going to be coordinated for discovery purposes? Are they going to be consolidated with one arbitrator? There's really no uniform way that these cases turn out, but that's what the process administrator's role is when we have a mass arbitration case come in that falls under our mass arbitration procedures. And the fees are very different in a mass arbitration case under our procedures than they are if you had 100,000 individually filed demands that were all going to go to hearing on an individual basis.
Well, and I definitely want to touch on that because it's a key aspect of this. But before we do that, let me just ask, does the process administrator, given that JAMS has a roster of 500 arbitrators, do those process administrators receive any kind of special training in how to do this, or are they just people? Okay.
Yeah, they do. That. Yeah, they do. Mass arbitrations are different from individual, business commercial arbitrations. So we absolutely want to make sure that the people that are doing this process administrator work are well versed in our rules and our procedures, but also detail-oriented, schedule-oriented, really, really understand the process. So that is why our procedures specify that JAMS selects the process administrator. Parties can agree upon a different process for selecting the process administrator, but arbitrators are people and they all have different skills. And so we want to make sure that this person that we're appointing has the knowledge of how a mass arbitration works, how batching might work, what a bellwether might look like, and is able to really design a process. It's not the merits arbitrator, it's really designing the process to get these cases through to a final hearing.
Now, The other thing I just wanted to touch on there is JAMS obviously has, its roster is not exclusively former judges, but there are obviously a significant number of both federal and state court judges that serve as JAMS arbitrators. Do the process administrators, are they drawn on for that type of skill? Like, do they have that type of background where they've dealt with class actions on the bench, or how do you select those guys?
Some do. And we have some retired federal judges who would not be interested in the process administrator work, right? They may be interested in the merits hearing work, but they may not want to have to figure out the whole process. But we have a variety of people and backgrounds that can do this process administrator work. We have lawyers and retired judges. It's just, number one is interest. We don't force this on our neutrals. We ask, are you interested in serving as a process administrator? If you are, we have training, we have resources. One of my co-drafters, Cliff Bloomfield, he is a neutral at JAMS as well. He's been instrumental in helping train upcoming process administrators. So we have a robust training system in general at JAMS. And we just, we make sure that the person doing this understands the importance to the plaintiffs and to the defendants in getting this right.
Interesting. Yeah. I mean, I think that's got to be probably one of the hardest phases is working out this process. And a couple of the options that you mentioned were bellwethers and batching. Can you just give a little bit more information about that?
Sure. So in some cases, the process administrator or the parties in conjunction with the process administrator may decide that they want, there may be 20,000 cases. And so they're going to select 10 or 15 to go to hearing to see, kind of where the final awards, where the merits arbitrators land after hearing the case, the facts, and evaluating the law. So they may bellwether them and see kind of the trend of where the final awards are going. They may batch. Let's pretend that we've got a case where we have 500 claimants and they are located in 5 states. And there's 100 people in each state, just to make it easy. So we may decide that we're going to batch them by state and have 100 claimants by state with an arbitrator, a merits arbitrator, hearing one batch for, let's say, Texas. We've got a Texas arbitrator hearing the case for the 100 Texas claimants. We've got Florida. We've got a Florida neutral hearing the case for the 100 Florida claimants. So we may batch it like that. The parties may decide we want to coordinate or consolidate all of the cases. And so we may be able to then put all 500 cases under one arbitrator. So there's really no one way that this works out. It's a kind of a creative process, but an efficient one.
Interesting. Okay, well, let me ask a slightly different question before we get to fees, because I think that's one that usually, it's obviously been a driver of some of this. How often do parties, in your experience, agree to the JAMS procedures in pre-dispute clauses? And how often are you seeing them agree to the procedures after the dispute has arisen?
Most of the time, I'd say great majority of the time, they're in the contract, the party's contract. So pre-dispute calls for our mass arbitration procedures. We have had a handful of cases where the parties have agreed to our specific mass arbitration procedures after filing their demands. And even before we developed the mass arbitration procedures, what we did see is parties would agree upon some kind of streamlined process after they filed. We'll sit down with the parties and they'll agree to something post-dispute. But most of the time, it is pre-dispute in the contract. That's where the parties both have, that's pre-dispute. So the parties are not fighting with each other. It's easy to agree on things. It's in the contract. There's no question about how we're going to do this. When the dispute has arisen, tensions are a little higher. So sometimes it takes a little longer to agree upon some kind of streamlined process. But we have had cases where the parties have agreed post-dispute to our mass arbitration procedures.
Interesting. Okay, well then let's talk about sort of the elephant in the room that drives a little bit of this. Describe to us the filing fees and how costs are assessed and all those things under the JAMS procedures, the sort of financial aspects, if you would.
And what I'll do is I'll tell you a little bit about what happens if you're not using our mass arbitration procedures, and then what happens if the parties are using our mass arbitration procedures. So first, we're going to assume these are consumer cases. The great majority of them are. So in consumer arbitration, we have our consumer minimum standards, which means that the consumer is only required to pay $250 as part of the arbitration process to JAMS, and that the company is responsible for the rest. And so our filing fees usually are paid 100% by the company, which is $2,000 is the filing fee for an individual case. The company either pays that full $2,000 or they pay $1,750 and the consumer pays $250. So it just depends on what the contract says, but the consumer never pays more than $250. So if you're not using our mass arbitration procedures, if you have 100,000 cases, the company is paying that $2,000 for all 100,000 cases. That's a huge filing fee. That's just the filing fee. That doesn't include arbitrator fees. That's just the filing fee. It's non-refundable. It's what we need to commence a case. So, we're talking several millions of dollars, tens of millions of dollars, could be hundreds of millions of dollars, I suppose. So our mass arbitration procedures are much more economically sustainable in that when we get a case that falls under these procedures, we assess a $7,500 filing fee. And either the company pays 100% of it or they pay $5,000 of it. And the consumer, the group of consumers, pay $2,500. And this is easily done because they're usually represented by the same lawyers. So we just bill that law firm $2,500. We bill the company $5,000. That gets the process rolling. That gets the process administrator appointed. The arbitration fees, then the process administrator charges his or her own rates, whatever they are. But then when we get to how we're going to go to final hearing, another benefit to the parties cost-wise is that we only charge an appointment fee per individual arbitrator. And this is where it can get a little bit confusing, but it helps to think of it as we charge an appointment fee per individual, not per number of arbitrators. So if we have 10 arbitrators selected to hear the merits of a mass arbitration, right? We've batched it into 10 batches and we've got 10 batches, we've got 10 arbitrators. The parties will pay that appointment fee for each individual arbitrator. So if there's 10 individual arbitrators, 10 appointment fees. But let's say we batch them into 10 batches, but we're going to have 3 arbitrators handle all 10. So some arbitrators might be handling 2 batches. You're still only paying for the individual arbitrator. You're not paying per batch, if that makes sense.
That does. Let me just unpack that a bit and back up 1 second. So in the scenario you gave, outside of in the absence of applying the procedures, a company could be facing, tens of millions to theoretically hundreds of millions of dollars in filing fees that they would have to bear based on mass consumer claims. But if these were to fall within the procedures and parties would agree to them, the company would pay at most $7,500 for all the cases that get filed.
Yes.
Or perhaps like $5,000.
Yes.
Okay.
Huge difference. Huge difference. Yeah.
Yeah. And a lot more certainty, obviously, too. Not just a smaller amount, but also like a fixed, a known liability. And then you're applying these things based on so then the process administrator is going to charge their own hourly rate to come up with the process. And then you're going to get into these fees that would apply once the merits arbitrators are selected.
Right. And, the merits arbitrators, again, they charge their own fees, their own rates. But then, we don't have additional filing fees, appointment fees per batch, per case. It's really per individual arbitrator selected.
Okay, right. So like if you chose 3 arbitrators, there'd be 3 appointment fees charged. If you charge 10, there'd be 10.
Yes.
Okay. Now, how are the merits arbitrators selected?
So that is the process arbitrator's responsibility, is to determine the way that the merits arbitrators will be appointed. Unless the contract is specific, the contract may be specific on how they want merits arbitrators appointed. We'll follow the contract. But otherwise, the process administrator determines that. Strike and rank. The parties could agree upon certain individuals. It would probably be either a strike and rank list or the parties would agree.
Okay, that's really helpful. Now, have there been any awards under the JAMS procedures that have been enforced thus far or challenged?
I don't know. I don't think so. I don't always hear about when we have a motion to vacate or when we have an award confirmed. We don't always know, but I don't think so. I don't think we've had any mass arbitration case go all the way to final hearing yet.
Okay, that's a great point. So have most of these settled out?
Yeah, a lot of them settle out, and a lot of them are still in that process where they're working with the process administrator to design the process and move it forward.
Okay, and at what point are most of these settling out when they do settle?
It could be any time. We've had some where they've settled as the process administrator has been appointed, right? Before the process administrator even gets involved, they'll settle. And sometimes it's after the process administrator has worked with the parties for a while. And then the parties like to, we're going to take this offline. We're going to put the case in abeyance and we're going to talk. We have some cases where the case is in abeyance right now. There's still the process administrator standing by, but the parties are talking, trying to settle the case.
Got it. So really any point in the process, I guess, as you say.
Yeah.
Well, that's all really helpful. Let me ask you then, switch gears a bit. What do you see as the future of mass arbitration?
I am really glad that I am not paid to predict the future because I would have been out of a job and broke. I would have said...
You and me both.
I would have said in 2022 that mass arbitration was going away, right? I mean, nobody was happy. Companies were furious about the filing fees. The process seemed so unwieldy to both sides. So I would have said that they would have been written out of contracts, that companies would have changed their terms of service to allow some kind of consolidated process. But honestly, I haven't seen that to the extent that I thought I would. We still get arbitrations filed that we'd consider mass arbitrations with multiple claimants and with very clear waivers of class action and prohibitions on consolidation or coordination. So I'm guessing that the future is mass arbitration isn't necessarily going away, but that the parties are going to expect a process that streamlines, coordinates for some reason or another, discovery, geography, that there's going to be some process that everybody adopts, that everybody expects to get these cases resolved. The courts haven't been consistent necessarily or all that helpful in really shedding a light on what they think is the appropriate way to deal with these cases. So the arbitration providers will keep doing what we're doing to make the process fair and efficient. And the parties, I think, will just come along with, there'll still be mass arbitrations, but there'll be a process for dealing with them that's more efficient than 100,000 individual hearings and final awards.
Right. Now, given that, you're saying, I think what you're saying sounds right to me, but given that this sort of constant focus on efficiency, are there any thoughts about updating the JAMS procedures, or are you going to let them play out for a while and see how they work?
We're going to let them play out for a bit longer. We're still very uncomfortable with forcing a process on parties. It's just not where we believe our power lies or our abilities lie, is to interfere with a contractual relationship between parties. So we're going to keep our procedures. We're going to continue to follow courts, talk to our clients, claimants, and respondents, do all of those things. But I think for what we're intending, the procedures work really well if parties adopt them.
Well, it sounds like it. And it sounds like the party autonomy aspect will keep those alive for a very, very long time.
Absolutely. Absolutely.
Well, Liz, thank you. This is really helpful. Let me just ask you before we wrap this up, do you have any tips you want to offer to listeners for things they might want to consider when looking at mass arbitration as a possibility?
Yeah, thank you for asking. I think one of the most important things that people can do is review their terms of service and make sure that the method for resolving disputes that's in your terms of service are what you want, and that you understand what the consequences are of proceeding in any certain way. I do think that mass arbitration procedures or some kind of clause that allows for the efficient resolution of disputes is so important And it's the way people take care of their customers, their employees, and they keep business going. So I would say review those terms of service, make sure that you're getting what you intended.
Yeah, that's a great tip. And definitely, make sure that there's a routine for doing that on some sort of reasonably fixed basis, because these things they're very important and they're changing constantly. It's an evolving landscape. So going back to look at these on a relatively fixed schedule is a really good idea. Well, Liz, thank you so much. This has been really informative and really, really helpful. So with that will conclude our discussion of the JAMS procedures for now. I say for now because I have a funny feeling we're going to be talking about these again in the future.
Absolutely.
I want to thank our guest, Liz, for enlightening us about the JAMS procedures, and I want to thank you, the audience, for listening. You should feel free to reach out to Bracewell today about anything you heard in today's podcast and any questions you might have. And you should also feel free to reach out to Liz. And we look forward to having you tune in for future episodes in our Arbitration Acumen series, and particularly the other episodes in the Mass Arbitration mini-series. So thank you, Liz, so much. As I say, we will probably be having you back in the future because I'm sure you will have more to talk about on this front. So thank you.
Thank you. I look forward to it.
Thank you for listening to this episode of Arbitration Acumen. We hope you found it insightful and informative, and we encourage you to share it with your colleagues if you did. You can reach out to any of our speakers by contacting them directly or by emailing arbitrationacumen@bracewell.com. We welcome any questions or suggestions you might have for future episodes. And please subscribe to our podcast channel to stay up to date with our latest content.